Good morning everyone, and welcome to this month's webinar in which we're going to be exploring the 4 primary areas of discrimination, which is a really important area of managing people. And before we start, we do want to introduce ourselves. I'm Victoria Templeton, the HR Knowledge Manager here at HR Solutions. I've worked for the business for 6 years and have worked in HR for over the last 25 years. And I'm joined today by Abby Ashford. So Abby is our Head of Consultancy Services. Abby's worked for HR Solutions for 19 years and also manages our team of HR consultants, as well as managing her own client base. So together we're going to bring you our experiences and knowledge of discrimination in employment with a focus on preventing. And you'll notice that we've placed you all on mute today. However, as usual, we do want to get your involvement in the discussion, and we'll do that in several ways. Firstly, we'll invite you to ask us your questions and we'll answer these at the end of the session. And to do this, you simply type your question in the panel box as we are showing here on your screen. And another way in which we like your input is through using polls. So these not only help to steer the webinar, but it allows us all to share how the topic is being managed in our own workplaces, and actually can help share ideas of best practice as well. So when you see this slide, we're going to be running a poll or several polls. They are confidential. We only publish the results to the question. So we do welcome as many of you today sharing your insights with us as well. So the purpose of today is to explore the main types of discrimination, because it will ultimately help assist you in preventing it from occurring. Clearly, we don't want anyone facing a claim of this type, but should you receive a claim, then I'm going to just explain to you a little bit more about the tribunal system, which will really help to focus on the important and crucial steps of risk management and prevention. So we're going to share with you ways in which you can protect the business and what that looks like in practical terms. But I do also want to really highlight another important aspect, and that is, whilst good employment practices are essential to protect the business from costly claims, we mustn't also forget that the practical measures that Abby and I are going to be talking about today is about wanting to treat people fairly and to not have anyone suffer any detriment because of any characteristic they hold. It is also very much about doing the right thing and treating people as you would want to be treated. To end the session, we're going to bring you the latest news on what's in store for us with regards to equality law changes. We have a lot of information available that will assist you in preventing discrimination, which I'm going to share with you towards the end. And as I said a moment ago, we're going to finish with taking your questions live. A copy of today's slides will be sent out in the coming days along with the recording. So do please share that recording around your management teams as well, because this is such an important topic. And so without further ado, we're going to launch straight into the first 3 quick polls. The first one, so let me just bring that up, is around, just so we can understand where you're all operating and get an idea of everybody that's on the session today. So are you operating in a micro, small, medium or large organisation? So you should see the poll on the screen now. So I'll just keep that open for a few moments. As I said, these polls just help us with the ongoing webinar, and it's also very insightful to everybody on the session today. So I'll just wait a few more moments before I close the poll and share with everybody. Okay, let's close that poll, and I'm just going to share that. So Abby, today on the session we've got predominantly attendees from the medium-sized organisations, so those employing 50 to 249. So that's our major group, but obviously we've got people reflecting all aspects of organisation sizes.
Yeah, that's lovely to see. Welcome everybody. Really looking forward to going through some of the other poll results as we go through. Brilliant.
And so let's then call up the next poll. So when it comes to human resource management, who is responsible for that in your organisation? We can see it carried out in a number of different ways. So how do you do it in your own workplace? So the poll should be showing now. Wait a few more moments and then I'll close it and share the results. Okay, let's close that and share. So what do we have? So again, everybody's represented here. Yes, we see it a lot, business owners also being responsible for HR, or having another person in the organisation that has those added duties. But predominantly, most of you here today have your own in-house HR teams. And like I say, a recording will be shared out, so please feel free to share it across your HR teams as well. And then finally, in this section, a poll in regards to our topic. And that is around how many of you have been involved in defending a discrimination claim? Let's see. I think my system's a little bit slow today. Keep open for a few more moments and then we can have a look. Okay, let's close that. Maybe let's see what the breakdown is here. So let's see. So 35% of you have been involved at some point in defending a discrimination claim at work, while 65% of you haven't, and hopefully you won't. Abby, does that surprise you, that proportion of numbers?
It's quite worrying, I think, that it is that high, I would say, because I'm presuming that people interpreted the question as actually defending a tribunal claim as opposed to just, inverted commas, looking after one internally. But yeah, that's quite high that people have had to go through that, because as you know, Victoria, it's not a nice experience, is it, having to do that?
Not at all, no, not at all. But all parties. Okay. Thank you for that. So now, without further ado, we're going to move on to the session. So I'm going to just initially start off with an overview of discrimination. Navigating the complexities of employment law can feel like walking through a minefield. Obviously, with the time that we have today, it's a high-level overview, and this initial bit is around the context. So hopefully you'll all know about the Equality Act of 2010. It's our main piece of discrimination legislation that protects those who hold one of these protected characteristics, as you can see here on the screen, from being discriminated against. It's actually a really broad piece of legislation because it doesn't just apply to employment, but it also extends outside of employment matters. So, for example, in the provision of services. So you'll see all the protected characteristics listed here, but you'll notice there's one that's in a grey shaded box, and that's to indicate that it's relevant only to Northern Ireland. So there is that additional protected characteristic of political opinion. It doesn't apply to the other nations of England, Scotland and Wales, but it's obviously important that I share that because obviously some of you may have business operations that actually operate in Northern Ireland. So I wanted to highlight that. And along with the grounds on which a person can be discriminated against, it's really necessary to understand the way in which somebody can be discriminated. And so I'm going to just take you through that in a second. So first of all, in order to be able to claim discrimination, you don't need any qualifying service because it is a day one right. It's not like the current rules around unfair dismissals where you have to have that 2-year service at the moment. Anybody can claim discrimination from day one. Secondly, those who are protected actually go beyond employees, so workers can claim discrimination as well as self-employed, and it also goes even further in that job applicants can put a claim in for discrimination, as well as ex-employees on leaving. They also have the ability to bring a claim for discrimination if they hold one of these characteristics and they believe perhaps the reference that was given about them was discriminatory, or the hiring decision that was taken was discriminatory. So it's really important to understand actually the scale of the legal obligations. But we also need to understand the way in which discrimination occurs, and there's four main areas, as you'll see here. So I'm going to provide some examples shortly, but first let me just set the context. So first of all, you have direct discrimination, where someone is treated less favourably to someone, and that treatment is because of one of those protected characteristics that I've just shown on that previous slide. It's perhaps the most obvious and easily identifiable because the treatment is openly different. There can be no legal defence for it, so it will always be unlawful, whether the act was intentional or not. Indirect discrimination, on the other hand, is where an organisation applies a rule, a policy, or a practice that applies to everybody, but actually, in reality, it disadvantages a group of workers that would hold a protected characteristic that I've just highlighted, and that treatment, they're treated less favourably because of one of those protected characteristics. It's actually quite hard to spot because the rules or policy may look fair on the surface, but actually it has hidden effects. With this type of discrimination, the thing that I would say is that in certain exceptional circumstances, it may be lawful, but the employer must be able to justify any discriminatory action as being proportionate and proportionate way to achieving a legitimate aim, i.e. that the organisation has no other way of achieving that aim through non-discriminatory rules. But that is quite a tough burden, if you like, to demonstrate, but just flagging there. You then also have victimisation. So this is where it's unlawful to treat a person less favourably because they've committed what's known as a protected act. So protected acts include the fact that they've brought previous legal proceedings against the organisation or the perpetrator. They perhaps may have given evidence at a disciplinary or grievance hearing or at tribunal, or they're making complaints about the perpetrator or the employer or their alleged discriminatory practices. The individual would have to show that the reason for that less favourable treatment is because of the protected act and that it's not for some other unrelated reason. And then finally, the fourth area is harassment, and that's conduct, and it can include conduct of a sexual nature, but it's conduct that has the purpose of violating a person's dignity or creating an intimidating, hostile, degrading, humiliating or offensive working environment. And the conduct is because of a person's protected characteristic, such as age, disability, gender reassignment, for example. When we think of sexual harassment, it has the same definition, except that unwanted conduct is specifically of a sexual nature. And actually, it is distinct in law from the harassment that I've just sort of highlighted, that is typically related to your sex. So there will be additional legal obligations in this area when it comes to sexual harassment. And we've done several webinars on this area, so do check those out if you can. But that's not all. Did you know that there are also other types of discrimination that can occur within one of these four main types? And I'm going to show you what these are now. And there's something called prohibited conduct that provides other avenues for discrimination claims for some of those protected characteristics, not necessarily all of the protected characteristics. So the first one is discrimination by association. So as the term implies, it's where there's an act of direct discrimination. So you're discriminating against someone because of who they associate themselves with. And that someone is has that protected characteristic. There's also discrimination by perception, which again is a form of direct discrimination. And it's when somebody is discriminated against because others think that they have a protected characteristic, even if they don't. You then have two further forms of discrimination relating to the protected characteristic of disability. First, there's the act of discrimination arising from the disability, and that's where someone is treated unfavourably because of something connected to the disability rather than the disability itself. And the second one is around the legal duty to make reasonable adjustments for someone with a disability. Adjustments are those changes an employer makes to remove or reduce a disadvantage. And so where there's that failure to make a reasonable adjustment, then that is a form of disability direct discrimination. So as I said, it is a minefield when navigating this area of law. I'm going to share some examples before we consider the more practical side of dealing with discrimination and thinking about tribunals as well. So if we take them one by one, so in direct discrimination, the example here is where you have a woman who is not promoted because it's assumed that she won't be flexible due to having a young family. That is clearly an example of direct discrimination. When we think about indirect and this piece around applying a policy or rule, so the scenario here is a job specification for a management role includes a requirement that the role is full-time. So on the face of it, it doesn't seem discriminatory, but actually in practice, what it does is it discriminates against people from certain groups. So for example, if you're applying a policy that is requiring the role to be full-time, it's actually a criteria that prevents women from applying for those roles, because typically it's the woman that works part-time when raising a family or caring responsibilities. When it comes to victimisation, then the example here we have is a worker that's supporting a colleague in a formal grievance case, and then they go on to receive a negative performance review that's not actually based on their actual performance. That's going to be as a result of a protected act, i.e. they supported as a rep in a grievance process. So that's how we can illustrate the victimisation. And then harassment, could be making repeated jokes about a colleague's age, for example. That would constitute harassment. And then those four other areas that I spoke about. The discrimination by association. So if you have a manager who denies promotion to an employee because they're concerned the employee will take excessive time off to care for their disabled child, this could be classed as discrimination by association. It is the child that has the disability, not the employee. But if that decision taken by the manager is because of those reasons, then that's where you have discrimination by association. With discrimination by perception, then if you have somebody deciding not to promote a highly competent employee because they're assuming they're too young, they won't be taken seriously by clients, even though the employee is a few years older than the manager believes. That's a perception that that manager's holding and is making a decision because of it. And that's the example of discrimination by perception. And then these last two that relate to the disability characteristic. So arising from disability is all about, for example, an employee's performance deteriorates due to the medication they're taking that's needed for their disability. The manager issues them with a warning for poor performance, and that is an example of how discrimination can arise from a disability. It means they've taken action arising from the disability and is discriminatory. This final scenario, the example is where a person's disability means they cannot work as quickly as other employees in the team. They ask for their workload to be slightly reduced as a reasonable adjustment. but the employer refuses because they feel it's unfair if one person is allowed to do less work than others. That is a failure to make reasonable adjustments. So they're sort of the examples to help sort of bring to life the legal context, if you like. We're now going to move on to thinking more practically about discrimination. We're going to start off with tribunals and looking at the legal framework around that. And Abby and I are going to discuss the practical issues when discrimination does occur. And just, I guess, to note that discrimination isn't always intentional. It can also be unintentional too. But in both events, employers are liable at tribunal. So I guess before we look at some statistics, just want to sort of speak and ask Abby about your experience. What is it, do you think, about discrimination claims in particular that you feel, I guess, organisations are most concerned about, you know, from your take on that?
Yeah, I think one of the key things is always going to be cost, especially at the moment, with how, you know, the economy is. One discrimination claim where a client of ours, you know, doesn't win, or any employer doesn't win, could bring the company to a close in terms of the amount of money. If it's one of the SMEs, for example, one of the micro employers. So cost is a huge thing. You know, I know you're going to go through the figures, Victoria, but it is uncapped. So it's sometimes it's hard to quantify what that cost might be, especially if the employer knows that they perhaps were in the wrong. So cost is always going to be a huge consideration. And of course, it's not just the cost if you lose, it's all different types of costs. It's the cost of the time of investigating it, looking into it, getting to the bottom of it. It's then the cost in how it impacts on people, and it's usually not just the person involved who's had to be incredibly brave and come forward about whatever behaviour their complaint is based on. There are other people involved as well, perhaps witnesses, others that have been impacted, colleagues, the person themselves. You know, it's going to be impacted on them. So then it all just broadens out, doesn't it?
It does, yeah.
There's bad PR, it could go on social media. I mean, you know, you do have people that will turn up to tribunals because they want to see how that employer is going to defend themselves. So that there's ultimately, you know, without being too scaremongering, it's pretty damn awful for this to impact on a company.
Yeah, and you raised some good points there, particularly that it's a public court hearing, so anybody can turn up. Generally, there are some exceptional situations where they wouldn't, but on the whole, anybody can go and watch a hearing. And so if you've got a case where it's been all over social media, it's in the press, you know, you could have your local newspaper turn up and listening to it. The whole experience of tribunals is stressful. You know, in a previous world that where I've worked previously, you know, I've been to cases where there've been 5 days of a tribunal hearing, and it's not only stressful for obviously the employee that obviously feels that they've been discriminated against, but from an organisation's point of view, you've got the costs in engaging barristers, solicitors, and even during those 5 days you had senior managers attending because it was such a big matter. So yes, like you say, without scaremongering, it's trying to balance seriousness of it. But what we'll do now over the coming slides is talk through some practical steps and actually how you can look to prevent claims and discrimination. But on the back of that discussion now, this slide is really showing you how in discrimination claims tribunals award compensation in respect to injury to feelings. The amount does very much depend on the nature and severity of the discriminatory acts or act, how long it's gone on for, and the degree to which it hurt or distressed the person. And there is a famous tribunal case that paved the way to show how awards are calculated, and it's known as the Vento bands, and they're made up of 3 levels, and with an exceptional one, as you can see here. It's for the tribunal to decide which band applies and where the award should fall within that band. It's not legally binding, but the Vento bands are widely followed and tribunals are generally required to have regard for them when determining compensation. So we're talking significant numbers here, and don't forget that is simply the award. We're not even factoring in the costs associated, the indirect costs, so time and effort in preparing and defending the claim. The award for compensation may also include other elements, so past loss of earnings or other financial loss, because the idea is that the compensation is about putting the claimant in the position they would have been if they had not suffered the discrimination. There's also the element about future loss of earnings, which may include stigma or career damage, losses for bringing a claim. You've got personal injury that could be physical, psychological, that has been caused by the discrimination or harassment. And then there's aggravated damages, which are awarded when the respondent has behaved in a malicious or insulting or oppressive manner, as well as punitive damages, which can be awarded in regards to how an employer has conducted themselves. So we are talking big money here in tribunals. So I think now's a good opportunity to run a few of our polls, and I'm going to raise the first one where Abby and I are going to talk through the results and share our thoughts. So let's go to some statistics. Now, the latest stats that we've got available are from 2023 to 24, and I'm just intrigued to get your thoughts. Which do you think was the highest discrimination? Which banding do you think the highest discrimination award was paid in that period? So hopefully you've got the poll showing. Let's just see. Yeah, and these. Do you think the highest award was less than 20,000? And remember, we're just talking about the award here. Leave it open for you a little bit longer. Okay. Last few votes, and then we're going to close the poll. Okay, let's close that, and let's see what you all think. Here we go. We've got it on the screen. Yeah. So, Abby, what have we got? 46% of you between 101,000 and 500,000. Most of you are in that bracket. Just a few, 2% of you think under the 20,000. Okay, interesting. Have you got any initial thoughts to those statistics? Okay.
Yeah, I mean, I was surprised when I saw what the answer was. I knew it was going to be high, but yeah, I'll let you have the glory of saying how much.
It's actually 995,128. So it's over the 500,000. So that is the highest discrimination award paid in the 2023-24 data that we have, which is mind-boggling. And the next poll is actually, I'm intrigued to know, which protected characteristic do you think that award relates to? And I'm going to just launch the poll here. Clearly, I can't put all protected characteristics up on here, just to clarify this, because we're limited to how many options. I'll try to do it as early as I can. So let's see. I'll keep the votes open for a while. So that award of £995,128, do you think it was made in relation to a disability claim, gender reassignment, marriage and civil partnership, pregnancy and maternity, or sex? I'll keep it open a little bit longer. Okay, let's close this, and I'm going to share the results. Hopefully they're showing now. So the £995,000 was actually paid in respect of sex discrimination. So interestingly, I can see half of you, 50%, saying disability, and then we have pregnancy and maternity and gender reassignment generally is the follow-up ones, marriage and civil partnership at 1%. So yeah, so sex discrimination saw the highest award paid. And I'm going to run another poll here, Abby, because I'm going to do the next one, which is about which protected characteristic do you think was awarded the second highest award? And the second highest award was 964,000. Okay, I'll leave it open a little bit longer, final votes, and then I'll close it. Okay, I'm going to close the poll and share the results. Let's see what we've got. So most of you believe disability is the second highest, and actually you're correct. Disability is the second highest award that was paid out in that period. And so we've got, you know, sex and disabilities are top forms of discrimination in employment. I'm probably not surprised, but I guess, you know, I work in HR and do my research and everything and my reading. Abby, what do you think to those?
Yeah, it is interesting. And to be honest with you, if I hadn't have known the figures before, I'd have gone with race. I thought that would have been the top one. But yeah, sex and disability, I can see how that would happen. And I was interested in the poll just before when gender reassignment had got a decent number of votes as well, because there's, you know, been so much in the press, hasn't there, about trans cases. So I thought maybe that would have contributed to those votes. But yes, sex and disability, that it's just we know from our job, Victoria, we're having cases on those two topics daily, weekly. So yeah, not a shocker.
Yeah, no, and I think disability in particular, we see that sickness absence is significantly increasing in organisations. We're seeing statistics, reports in publications showing that that is the case, and a big chunk of the rise in sickness absence is because of mental ill health as well, and that is potentially a disability under the Equality Act, because you know, as you know, it's not just physical impairment but also mental as well. So thank you for that. And then I'm just going to quickly flag a couple of awards and just open up a new poll, because this is quite interesting. So I've obviously shared with you all the maximum amount, but actually we need to think about what's more representative of the average. So we look at median awards because that is generally more representative. It's not skewed by exceptionally high payouts. So I'd be interested to know how you vote on this one here. What do you think was the median award paid for? This was the age discrimination one. So, keep it open a little bit longer. Okay, let's close. So the median award paid for age discrimination, as an example, here we go. What do you all think? Let's see the stats. So 48% of you say between 12,134, and then followed by 36.4 to 60,700. Now, Abby, can you just double check on that next slide the age median award for me, please? Because I've it's gone out my head what the actual result was.
Yeah, so 86,349.
Wow. And that's the median. So it's interesting, and that's more of a realistic amount. I'm going to launch the next one and then we'll move on. And this is about disability, the median awards for disability. What do you think that will have been? So remember that disability was the second highest payout maximum. This is now looking at the median, so more representative of reality, I guess. So let's close this. I'm going to share the results, see what we've got. So most of you believe exceeding 60,700 as the median. Abby, can you just clarify the number for me, because I haven't got them in front of me at the moment?
Sure.
The disability.
17,218.
Wow. Yeah, so all big numbers. What I'm going to do now is going to hide that poll, and I'm going to move the session on, because actually what we've got for you here on the next slide is the summary. So as I said, you'll have the slides sent out in due course. You probably want to, looking at this table, consider the median like I've just gone through, because that's more realistic, but be aware that actually there's no cap for discrimination, but in reality in this period these are the maximum payouts that have been paid on the left here. So food for thought there. So of course it isn't all about the costs of awards. You need to consider the time, effort and people involved in the actual process of dealing with a claim before any hearing. And seeking that early and ongoing HR advice is always vital to help you in those early days of having received it, particularly because you have a strict time frame for responding to a claim, which is your ET3 response. This form is your first formal opportunity to set out your defence. It's got to be completed accurately and comprehensively, addressing each point of the claim, because of, a well-drafted ET3 establishes the core arguments and legal basis for your defence, demonstrating a clear and concise position at tribunal. You have to consider the process that's involved in gathering evidence. So effective evidence gathering is a foundation of a strong case. It includes collecting all relevant documents, contracts, policies, handbooks, emails, meeting minutes, and other relevant key documents. That comprehensive collection of evidence allows the employer to corroborate their version of events and refute the claimant's allegations with tangible proof, which is essentially. You then have, of course, evidence in the form of witness interviews. I don't know if anybody on here has been a witness at tribunal, but the actual preparing the witness statement, etc., is intense. Witness interviews are essential for understanding the full context of events leading to the claim. So if you've got discrimination claims around a disciplinary process, you'd have probably the investigation manager, the disciplinary hearing manager, and the appeal manager, for example. It allows the employer to identify key individuals who have that first-hand knowledge and understand their perspective. But the work involved in taking those statements is huge. You've got to draft the formal witness statements detailing the facts relevant to the case. It's a critical part of evidence presented at the hearing. Well-drafted statements are clear, factual, concise, provide that consistent narrative that supports the employer's defence. And it is such a time-consuming process. And then there's an element of, you know, the witness statement has to be reflective of the witnesses' viewpoints and has to be accurate and in the words that they would use. So it is a very time-intensive process in collating those. You then have the whole process of collating the bundle. So the bundle is the filing that basically contains all the evidence at tribunal. You've got to paginate it, or the documents that are being referred on, and quite often it's down to the employer to do all that, not the claimant. There'll then be a point in that process of preparing your defence as to whether you consider engaging legal counsel. So engaging with barristers, solicitors, etc. That is in itself costly, and obviously, depending on the nature of the case, most likely necessary and reasonable, and something that should be done. Then you've got all the correspondence between the parties. So there's got to be that clear and professional correspondence between the claimant, their legal representatives throughout that process. It involves exchanging information, possibly negotiating a settlement or agreeing tribunal procedural matters, for example, but there's a lot of time and effort involved in that. And then towards the end, as you get nearer to the tribunal date, you have things like your case management hearing. That's a procedural meeting where the tribunal judge sets the timetable for the case, outlines issues to be decided, etc. And then ultimately you have that hearing where, as I said, it's most of the time open to the public. They can last one day, weeks. I've known them, like I said earlier, for a whole week at a time. So it all depends on the nature of the claims and the complexity. But yeah, I mean, there's a lot involved in that. And I think what we're going to look at now is from a risk management point of view, because I think it's fair to say that the risk of an employee raising a grievance or worse, making a claim for discrimination is a significant concern for all businesses. Even if a business successfully defends a claim, the financial and reputational damage can be severe, as I've obviously gone through in these slides so far. Risk management is crucial in preventing and defending against a tribunal claim. And we're going to now look at how you can mitigate those risks. But I think, Abby, now is probably a good time just to get your perspective and your insights and thoughts on defending claims, especially for small employers. What would you say are the key areas of focus, and what are your thoughts?
Yeah, I mean, my initial thoughts are sympathy, to be honest with you, with especially some of our smaller organisations we work with, where I think their first thought is that an employee has put in a complaint of discrimination, perhaps a grievance. They don't necessarily believe that to be true. They know they've got to do something about it and can't ignore it. That's like your first tick in the books. But I think what sometimes don't appreciate is that the burden of proof will switch to them. That the first thing is that person has been brave. Let's take it as read that that's a genuine complaint. So they've been brave enough to raise their hand and say, I've been discriminated against or harassed, bullied. And then they hand that over, that important piece of information, to someone trusted within their company or business to deal with it. And it can be easy to be defensive to begin with, to think, no, I've worked with that manager who's being accused for years. I know them as a friend, their family, and they wouldn't have done that. They talk to me fine. And so I think that initial hurdle of getting over the fact that something negative might have happened in your company is quite a difficult and an emotional one to handle. So it's about removing that emotion and really making sure that something is dealt with correctly and so that you can defend it, because that burden of proof will switch to you as the employer. to prove that there hasn't been discrimination, which can be really difficult to prove, actually. And so, you know, tribunals aren't stupid. They're very clever people that will look at context. You know, they will look at whether your witnesses are credible. They will look at whether you've got gaps in your documentation. And if you're a small employer that does lots of things by word of mouth rather than documenting it, then it's going to be really, really difficult to defend that claim. You know, you can't just say, well, our culture is this and it's great and everyone looks happy, when there are things happening that aren't fitting with that cultural and those values that you might have in place. So yeah, it's high reputational stakes, and it's really about knowing your business as well as you think you do. You know, you can get feedback from exit interviews, from if you do pulse surveys of any kind to find out how engaged your staff are. That goes a certain way to finding out how people feel.
Yeah.
But often there might be something brewing that you really genuinely didn't know about, and the first thing you find out is a grievance or a tribunal complaint, or ACAS gets in touch, and then straight away you're into defence mode, and you have to be. So yeah, those are my initial thoughts on answering that question.
That's interesting, and you started off with sympathy and the emotional side of it, and like I said at the start, all parties involved, you know, it's tremendously stressful, the whole piece around being accused of, or if you're the employee who genuinely has been discriminated, to actually be discriminated. It really is really, really stressful, and can have emotional impact. So if you are an organisation that has things like your EAP, Employee Assistance Programme schemes, things like that are really good. And I'm going to come on now to talking through some action plan that you can probably look to build on, so that you can help create that culture in your own workplace that prevents discrimination. That's what we need. We need it to be prevented and not happening at all. But if it does happen, then you need to also have measures in place to be able to deal with claims swiftly, effectively, and fairly. So I'm going to talk through some essential elements of risk management. And I think the first thing really is, I think now is a good opportunity, you know, going away from today's session, to think about actually how do the working practices and policies in my own workplace conform to equality laws and discrimination laws. And a risk audit is a good starting point. A risk audit systematically reviews your working practices, starting from recruitment all the way through to termination of employment. And so it's about identifying potential areas of non-compliance with employment law. It's about pinpointing vulnerabilities in your organisation, such as if there's inconsistent application of policies or discriminatory practices. Remember what I said about indirect discrimination, it might not be obvious. And so it's allowing for you to take that corrective action before anything escalates or rises into an illegal claim. And so carrying out a risk audit is a proactive approach, not only prevents claims, but also demonstrates due diligence, which could be a key factor in a tribunal's decision. And I've got some information more about some tools that we've got available to help you on that in the coming slides. The second piece is around carrying out equality impact assessments. So it's about evaluating new and existing policies to ensure they don't unfairly discriminate with protected characteristics. Because if you're identifying and addressing potential discriminatory effects, businesses can then prevent the claims of unlawful discrimination and demonstrate that commitment to equality. So the documentation itself also serves as a valuable piece of evidence when defending against such claims. Another major area of defence at tribunal is the piece around training, and it should never be a one-off training course. It must be ongoing, it must be reviewed and updated. Training must be given to managers and employees on employment law, anti-discrimination policies and best practices, because it ensures everyone understands their legal obligations, the company's expectations. It reduces the risk of unintentional policy breaches or discriminatory behaviour. And then in the event of a claim, evidence of a comprehensive training programme can demonstrate the business took reasonable steps to prevent the issue, strengthening the defence. And we had a case in recent years, I'd probably say 5 years ago roughly, where actually it ruled in favour of the employee because the training that they received wasn't sufficient enough. It was outdated, it was hadn't been refreshed, it wasn't relevant. And so actually it is so important to invest in training for your workforce. And then another key element is about having robust contracts, policies and handbooks in place. That is key to your defence. Having them that are legally compliant and clearly communicated is fundamental. So it's all very well having legally compliant policies, but actually you need to also be communicating them to everybody and making them available to all, and in a way that's easy to understand. So the documents set out rights, responsibilities of both the employer and employee. They can provide that clear framework for the employment relationship, and so they do serve as that primary defence against claims. And they can be used to prove that a specific action was in line with established company policy and procedures. These are not documents that once created, like I say, are left in place. In order to be successful in defending a claim, you need to be able to show that they are monitored, reviewed, updated, and ensure that the rules set out within them are not indirectly discriminatory. And then moving on to managing third-party relationships, and this is probably going to come up in the news later this year, early next, because the law is changing on this. But when working with contractors, freelancers, temporary agencies, it's really crucial that to properly manage third-party relationships, you've got those clear contracts, agreements in place that provide that robust statement around legal status. Are they self-employed? Are they employee? And you've got to take measures to basically prevent liability for actions of a third party. And so having robust frameworks can clearly describe responsibilities, mitigate legal risk associated with these relationships. And the law is changing next year around the sexual harassment duty and discrimination harassment, because it's broadening out third-party relationships. Monitoring your workplace is also vital. So key employment metrics such as disciplinary actions, grievances, promotions, pay scales, that all helps in identifying patterns or disparities that could indicate a systemic issue, such as unconscious bias. So proactive monitoring allows for early intervention, correction and preventing a potential claim. And if a claim is made, that data can be used to show that a specific action was an isolated incident and not part of a broader discriminatory pattern. It's also important to build that culture that's got clear, transparent communication, because it builds trust, reduces misunderstandings that can lead to dispute. And keeping employees informed about policies, expectations, changes in rules are so important, and that they're in a clear, accessible manner, because that all minimises the risk of a claim. Documented communications also serve as evidence in a tribunal, demonstrating that as an employee you acted reasonably and fairly. Conflict resolution is a really big piece, and like I sort of alluded to earlier, it's about prevention in the first place. So nipping things in the bud. You know, if you're seeing signs of conflict, it's about making sure you've got the right processes in place to deal with that and to address it. So it could be mediation or formal grievance procedures. These are internal mechanisms to resolving disputes before they escalate to an employment tribunal. Appeals processes as part of that are also vital, because it allows you to draw out potential tribunal issues. And they can actually lead to mutually acceptable solutions. So whether there's a settlement that's negotiated, thus avoiding the time, cost and reputational damage of any claims. And I guess I can't not include early HR engagement. And I may be biased because as a HR professional working in HR, I can't tell you how vital it is to seek out early HR engagement and advice when managing a situation. It's crucial because it ensures all actions that are taken from the moment a potential dispute arises are legally sound and well documented. And having that proactive approach, working with a HR partner team, helps you to build that strong defence from the outset, because HR can then guide managers on correct procedures, ensuring that if there are any disciplinary or grievance processes, that they're followed fairly and consistently. Remember, it's so important to be consistent as well in your decision making of cases. So what is more important actually is to work alongside your HR teams to prevent issues from arising in the first place and having those good relationships. And with the changes that we're going to see coming up in the next couple of years with the Employment Rights Bill, working with your HR teams to assess, review, update policies, handbooks, contracts, as well as providing training on an ongoing basis is really going to support in protecting your business from claims. And I suppose this leads me on now, Abby, to get your thoughts around operationally. Do you have any comments or thoughts around prevention?
Yeah, and it's interesting just listening to you talking there about, in particular, the prevention of sex discrimination that obviously came in the back of last year and is likely to be updated with the third party. It just reminded me of the time that I took with our clients going through risk assessments to try and put in place prevention measures. Yeah. And I'm obviously just talking about sex discrimination at the moment, but it is actually really difficult when you start thinking, what can we do to prevent people who all have got different upbringings, different backgrounds, different views on life, and then they all come into a particular workplace, and then you have to present yourself as a credible ambassador of that company, right? So you might have a really, really good values competency framework, behavioural framework. You might have a great culture, but if you've got individuals whose views deep down are not cognizant with what your values are or your culture that you want to create, it can be really, really difficult. And there's only so far that you can go when filling in a risk assessment form, for example, on how can we try and prevent discrimination happening in the workplace. So it is difficult, but that doesn't mean we should, shy away from it. And certainly if you have got people who've got views and they might not even know, right? You mentioned unconscious bias. They might not even know that their views are, discriminatory. And so that you might constantly have a brewing issue that will come to the fore at some point, potentially. And if that's recognised by a manager or by HR, whoever it might be, it might be that individual intervention is needed, or it might be that you say to yourselves, well, yes, okay, we've done this training session on race discrimination, for example, or disability, but we need to make sure we've covered all bases, all the protected characteristics, and not just do a one-off training session. And I think also that we need to learn as much as we can from tribunal rulings. We know time after time when we read what the judges and the panels have concluded, that we cannot just rely on having a policy, so having an equal ops policy or an inclusion policy, whatever it's called. We can't just rely on that. But then, because a policy is a document, isn't it? It tells us what the stance is of the company, how we want people to behave, and it perhaps gives some pointers, a procedure on what to do if something happens. But what it doesn't do is document how great you are. So I think really it's just making sure you've got everything in place fundamentally, your policies, your culture, your values, all that sort of thing. Then you bring in the training and development and some individual interventions where you can see that perhaps people need to have some unconscious bias training or some coaching, whatever it might be. And then after that, it is the continual managing of people in an absolutely genuine and fair way,
Yeah.
recognising and celebrating difference. And that really is the key, I think, to prevention.
Yeah, brilliant. Well said, Abby. Yeah.
Thank you.
Brilliant. What I'm going to do, I'm going to move, I'm conscious of time. I'm going to run a poll, and it's really just to get a feel from you all around, you know, what sort of information or support do you think you'd like to see from us, whether we get in contact with you on it, whether it's on our website, what kind of information would you like to see from what we're being discussed today? And I'll leave that poll open for a moment. And hopefully we should probably be 5, maybe 10 minutes more. So if you can spare that extra time, that would be really great. We appreciate you staying on. So I'll keep this open a little bit longer, and then we'll carry on. Okay, I'm going to close that now, I think. There we go. Brilliant, thank you. And then I think just carry on with these slides next. Really, so this section is just to let you know the resources we do have available. So I talked about risk audit earlier, so critical for understanding your position now in terms of where you sit with compliance. And it's a free tool for everybody to use. There's a QR code there. And what it will do is generate a report for you, and it will highlight in that report recommendations for where you can address those gaps in compliance. So that's a really important tool, and hope you can all get to use that and just assess what your workplace is like at this point in time. We also have business impact assessments, so we're working very hard on preparing for the Employment Rights Bill. I've developed several impact assessments. Again, you've got them available via the QR code here. There's one in particular that's all to do with tribunals, because we're going to be seeing some changes in that area anyway. So do check those out and actually start thinking more broadly about all of the reforms as well. So there's a QR code there, and it should take you to the people plan as well. And then we're actually offering a free 30-minute consultation with one of our experienced HR advisors. So if you're dealing with it could be a discrimination issue, or it could be anything like performance, absence, or you're wanting to create that positive workplace culture, then try us out, give us a call. You've got a QR code there to get in touch, and you'll get to speak with one of our fab HR advisors in the team. So I'm only just going to highlight this quickly, because this in itself can take another webinar, but we are seeing reforms under the Employment Rights Bill. What you see here are all the potential changes that will impact on equality and tribunals. And so you can check out more information. If you're a knowledge-based user, we've got lots of information on the Employment Rights Bill that will cover all of these topics. If you don't have access to our knowledge base, then we are always on social media posting updates in terms of the Employment Rights Bill, and we also have a lot of articles and content on the website that we have. So do check that out. The piece that I want to flag is the tribunal time limits increasing from 3 months to 6 months. That's going to be massive, because if you think about it, it gives people that extra time to seek legal advice on their claims and issues. It gives them more than enough time to process a subject access request and therefore have all the data before submitting their ED1 application. So there too in particular, but do check out our resources that we've got available on our website and knowledge base. We have a roadmap as well for the Employment Rights Bill as we know it today. This is in accordance with the government's roadmap. So I would just want to draw your attention to the top piece there. So as soon as the bill's given royal assent, pretty much soon after, within 2 months, they're saying we'll see some reforms to do with trade unions, repealing many of the regulations that came in from the previous government. But April next year is a biggie in that we're going to see massive changes. So do check out our roadmap and all the information we've got on our website there. I'm going to run one final poll before we take your questions. So let me launch this. It's really if you want us to contact you after today in terms of our general services, and not necessarily to do with this topic. Just let us know if you'd love a conversation with us, if you'd rather have some literature sent out to you, or if you'd rather not at this moment in time, that's absolutely fine as well. So just let us know with the poll, and I'll keep that open for a moment. Okay, so let's see. I'm going to close the poll, a few more seconds to vote. Okay. And so I really appreciate everybody hanging about. It is unusual to overrun, I must say, but this is quite a complex topic today. So if you can stay, that's great. And I don't know, Abby, can you stay?
Yeah.
I should ask you as well. If there are any questions perhaps that you do want to share, Abby, or we can do a follow-up in writing with the answers to some questions. I don't know what you think.
Yeah, to be honest, we didn't have too many questions today. I've answered the majority of them. There's one about CPD that I just need to check with you. So apologies to the person that's asked that question. We'll come back to you on that because I'm not quite sure and I don't want to say the wrong thing. But yeah, the two other questions were, one was about somebody doing the sex discrimination prevention training like last November when it came in. Should we do it again? Which I think we've covered off in the webinar, but the answer is yes, in short, especially if you've had new hires. And then another one was interested in the actual cases that contributed to the high 900k, cases in sex discrimination. So I've sent over some details about one of the cases, Rebecca Callum versus West Midland Police. So it might be of interest to have a little look up.
Oh, brilliant! Thank you.
About it, really.
Oh, thank you for that, Abby. So let's just to let you know then, before we bring it to a close, we've got some webinars coming up next month. It's all around protecting the business from tribunal claims, so almost like a follow-up from today. And then the November one is around planning for change, because next year is going to be a massive year with the Employment Rights Bill. And in December, because we had the date of the budget pushed back by the government, it means we're just going to look at budget implications on HR management in December. And then we've got a couple of dates for January and February set. We're just refining the titles in those areas. And so we'll confirm that as soon as possible. And of course, we're already announcing our annual virtual employment law seminar. So be sure to sign up for that. If you'd like to keep in touch with us, do either drop us an email, you can give us a call, and then we're all on social media as well, and LinkedIn, so do check us out. Just want to say thank you to everybody for attending today. Apologies that we have overrun, but hopefully you found it informative, and thank you, Abby, for your support in running this session with me today. So I hope everybody has a good day and rest of the week, and we look forward to you joining our webinar next month. So thank you, everybody.
Thank you.
Thank you.